Welcome to Family Law Matters, the podcast presented by the Mealy Firm. Visit www.allfamilylaw.com or call 866-687-8561 to learn more. And now, here's your host.
Hey, thank you. Welcome in. We are here with Family Law Matters. We're going to be talking to you today about a lifetime of care. My name is Bill King with the Mealy Firm, and I am joined by three of my amazing colleagues, Dina Kismatulina.
Hello.
Stephanie Banks.
Hello, everybody.
And Cherish De La Cruz.
Hello.
And thank you all for joining me today to talk about why family law matters. So today we're going to talk to you. Last time, this is our second episode, and then the first episode of the podcast, we talked to you all about our core values and who we are as a firm and what we believe in and the message that and the services that we want to provide to our clients. Today, we're going to talk to you about those actual services. And so we'll jump right in. We do family law, which includes divorce, child support, custody, adoption, contempts, legitimations, paternity actions, and estate planning and probate and everything else in between. And we'll get down into the weeds of those in a little bit. But I do want to say that I love this notion that we help out clients from what we call cradle to grave, which means we help them from birth into their deathbed and beyond.
We had so much fun recording our first portion of the podcast, so I couldn't wait for today to continue. Our clients, so sometimes we deal with the clients and we help them even prior to birth of the child. For example, we do a lot of surrogacy contracts. We help people to get through IVF process on the legal side of that. And we help people from very early stages, for example, name change for minor children that could be very, very tiny, and all the way to making sure people are taken care of through divorce proceedings, through custody, through a modification of child support, when people adopt children. So we essentially, any aspect of family law, we definitely do it. And sometimes dynamics are very interesting because we get referrals from people we already helped in the past, and it's nice to know that people trust us and trust our level of services.
Absolutely. And one of the things that I think is very exciting about what we do, and that I think it's important for people to know, is that we also do international family law. So we have these very interesting, exciting cases in which we're dealing with some very unique or very targeted area of the law in terms of looking at, are we working with clients who are, in Europe or Africa or South America or Asia, and how does the law blend together? And so that's something else that we get to focus on and really utilize kind of the skills that we've been trained on.
It definitely, it sometimes causes issues with scheduling Zoom meetings because you have to figure out, what time is it on another continent? But that makes life all the more interesting.
Mm-hmm. And so, you talked an awful lot about the litigation side, and we can talk about, some of those specifics in those cases. But we also do estate planning and probate, which is relatively new area that the firm is focusing on. We've started that branch about 4 or 5 years ago, and we've had the privilege of being able to grow that and bring on two wonderful people who are managing different branches for the firm now. And I want to turn it over to them to be able to talk a little bit about those. But that's estate planning, probate, and also into probate litigation.
I am Cherish De La Cruz, and I am the managing attorney for estate planning. And the reason that I came to the Mealy Firm was a couple of things. First of all, I loved their core concept of leading with care. Initially, when I was interviewing with them, you could see it. What really resonated with me during the interview, and then also even afterwards in our day-to-day, you see in our daily actions and what we do that we truly care about the clients. And for estate planning, this means holding their hands when their loved ones are passing away or sick, or contemplating with them as they grow their business, their family business. And then also being a trusted resource for them in all times of their need. So, we get a lot of referrals from other attorneys, other colleagues, community leaders. And the reason that they choose us is because we truly care. And it's, done through all of our actions. Education is a key component in what we do. And, if you're listening out there and you want one of us to speak on any of these topics, we would be excited to do so, because leading with care really involves educating the community, which is what we're doing in this podcast, but also, the outreach that we do as community leaders, as leaders, board leaders, and being involved, but also, a helping hand where, you may need another attorney, a business attorney, a tax attorney, and we have an extensive network with which we vet and we communicate with, and we want to be part of your trusted team of advisors. So really the estate planning piece, and also from my own personal experience, I've needed estate planning because of my own cancer diagnosis. And that's why I'm passionate about it. And I want to make sure that everyone is protected, that we do it with care and love, and with no judgment. One of the things that I love about this firm is there is no judgment here. I think that we have clients from all over the world speak, different languages, but we approach each client and we treat them with care, like they are our family members.
Right, and it's extremely important to get estate planning documents in place, because what you're wanting to do is prevent future litigation, right?
Yes.
So you're wanting to put these in place so that everybody knows here's what's supposed to happen, here are how things are supposed to go. And so then when you pass away, your family has these instructions that lay out, here's where I want my property to go. Here's how I want to be cremated or buried. Here's where I want to be buried. Here's who gets my favorite T-shirt collection. Here's who gets my coin collection and my autographed baseball from Mickey Mantle and whatnot. But there are those instances where people don't put these in place, and that's where we transition into that litigation aspect or probate litigation. And I'll pass that over to Stephanie to talk a little bit about.
Well, thank you, Bill. My name is Stephanie Banks, and I am the managing attorney of probate, trust, and fiduciary law and litigation for the firm. And Bill is absolutely right. There are some times when people don't plan properly, and sometimes even if they do, there is a need for us as the Manili firm to step in and provide an excellent service to assist them through that process. Where someone has passed away, the probate court is involved, and we assist them with helping them go through that process in a way that is less stressful for them. We take them step by step. We help them with what they need to do as soon as the person has passed away. We help them once they have gotten all of the information to us, and we go to the court and petition for whatever the need is with respect to the individual, and making sure that an estate is opened and it is properly executed and handled and managed. We walk them through the administration process. And what I want to say in terms of the services that we provide is that encompasses one of our core values, is that we execute with excellence. We have a team that is assigned to your cases that takes the time to talk to you. And as Cherish says, we really do care, because we talk to you about what you are looking to accomplish. We're not just there to provide you with advice without incorporating your needs, your goals, your objectives into our strategic plan to make sure that you get that which you want as much as possible. Sometimes we are not able to give you everything, but we certainly will work as best as we can to accomplish your goals and objectives. And from a probate standpoint, there are a number of things that could take place from a probate court having jurisdiction over your case. If there is a will that has to be proven in the probate court, wishes of the person who passed away need to be followed. We can walk you through that process. If there was no will, and that happens a lot, if there was not a will, we can also walk you through that process. But I'm going to take a little bit of a time to talk about Cherish's area of the law and say, please get a plan, because if you don't, Georgia law will make a plan for you, and it may not always be what you want. So if you have a probate need, the Manili firm is the place for you to go. If you have a litigation need, the Manili place is for you to go, where you can go. If you have a need litigation-wise, then the Manili firm is where you should turn. We are happy to help you with anything that you need in the probate area.
Echoing on what Cherish and Stephanie touched up on, I'd like to go back to the point of no judgment. I mean, majority of the areas you can imagine, family law has some relevance to that. And it's especially interesting considering that we are not just practicing family law, but we are also practicing international family law that puts its own, an additional level of complexity on the issue. For example, for people from different background, from different culture, from different traditions, family looks different. There are certain maybe cultural things attached to how traditionally, for example, after passing of the head of the family, assets are divided, or what are the traditions or expectations. For example, a wife will be supported after divorce is done, is different in different cultures. So dealing with that plus requirements of the foreign law sometimes, that's what makes our life very, very interesting, and we are learning and we are researching and learning new things every day.
Absolutely. And one of the big things that I think that's important, and I want to bridge a gap here, is there's a notion that all of this intertwines in a way, right? This is all family law, and family law matters to all. And so when you're thinking about that, one of the things that we think through is on the divorce side or the probate litigation side or the estate planning side is how do these weave together and how can we advise clients? And so we have this idea of you are a client for life, right? And so any need that you have that addresses family law or anything that we can address for you through family law is something that we can do and we would be happy to do for you. And so kind of talking about how those intertwine, one of the things that we talk to our clients a lot about on the divorce side is how important it is to address your estate planning and to get that done, because a lot of people don't know or don't understand if you file for divorce and something happens to you, now your spouse who you're in the middle of a divorce litigation with has the decision to pull the plug or to do something related to your health. And I'm not so sure that that's going to be the decision that you want, right? Because you're just embroiled in this litigation, and now all of a sudden you have no say-so, and the person who you were up against does. And so thinking through documents like an advanced healthcare directive or a power of attorney to lay out, here's what I need to get done in order to make sure that if I am in litigation and something does happen to me, that I have somebody that I trust, that I know will make decisions for me that's in my best interest. Because although it is a fiduciary role, as we know as attorneys, people don't always act in accordance with that role. And so we have to be prepared and we have to work through, here's, worst case scenarios for you and here's how to prevent those, right? And so talking about that, I want to get into the weeds a little bit on cases. So I want to kind of start on the divorce side. So, when you're looking at a divorce and you're meeting with a client or a potential client, what are some of the issues that they may face or that you are going to be talking to them about what litigation is going to look like and what they're going to have to deal with?
First and foremost, we as a firm like to start with inquiring what are the client's priority and goals. How do they envision their life after whatever litigation we are discussing? For example, divorce. What's the most important part? Where is the emphasis? Is the custody of the minor children the most important portion? Is the division of assets the most important portion? Maybe the family has such amount of debt that we need to assist them and maybe try and bring in help from a bankruptcy attorney, for example, to make sure that the level of debt is reduced before the family heads into the divorce, and it further complicates things. So that's first and foremost. We essentially, I like to think about us as we can get clients where they want to be, and we know legal roads, but essentially the ultimate decision of what will happen at the end is belong to clients, and it's definitely different from different people. And again, going back to what we discussed from the very beginning, there is no judgment. I understand that everybody have to make a living, and for some people, maybe spending time with their family is more important than anything else in this world, and that's one priority. But there could be some other arrangements made, and we are trying to help as much as we can and educate our clients to help them reach the goals that they have. And the most important thing is, I think, I'm hoping, at least we are as a firm, we are really trying to part from that idea of the divorce as end of the world, end of everything. That's scorched ground, nothing left. Not really, even a piece that could, be pieced together. We are trying to make sure that even as we are going into divorce litigation, if necessary, and we use mediation, we're actively arbitration. So there are other alternatives, to hardcore litigation just in court. We want to make sure that we are already sprouting some hope for renewal and rebuilding after the end of the divorce. And it's very, very often that, for example, we helping our clients finalize the divorce, and the issue comes up that they need a trust to make sure that the children are taken care of, or maybe that's a part of the arrangement for college expenses, or they need to update their wills because then no longer married to their spouse, and that's who is the person who is supposed to be executor of the estate. In the case the other spouse would die. So it is so interconnected, and it's really kind of a living system, like a biosphere in a sense of it. So it's all connected, and it's important that each element is nourished. And I think it's especially important considering that we are doing international family law. So we have to think about consequences. Okay, if this is the judgment that American courts will come up with, how could that judgment be enforced in Trinidad or in Spain or in Mexico? So we need to think ahead to not end up just with a piece of paper in our hands and no further road or for our clients. I know we are discussing divorce right now, but it comes across a lot of subjects in family law. For example, international child support. Not that many firms are actually even dealing with that issue, but we have our clients are getting child support paid from abroad, whether that to be Japan, Germany, or other countries. And that is something that, it's hard enough, for example, in Georgia to get child support services to open a case if the defendant resides in the neighboring county. So it's very hard to make sure, you're staying on track with that. But there are systems in place, there are conventions, there are agreements, and it is possible to get a child support from Germany or Japan, for example. We've done it many times. And it's just a question of research and determination.
Yeah, absolutely. And I love how you started at the top to say, we listen to what our clients' goals are, and then you talked about how different our clientele is. And I think that's really exciting or a good place to start from, because a lot of people have this notion that the law is very rigid and you just walk in and this is how it is and this is how it gets done. But one of the things that we talk about at the firm and what we train on and what we work on is being able to come up with very sound strategy that is it's flexible, and we are able to shift and create these situations in which we come up with these plans, these thoughts, these ideas that help with the clients, and it thoughtfully addresses the things that they are going through, right? So we're talking about a situation where somebody may have different ideals who's from a different culture, right? And so it doesn't naturally fit within this idea of, well, we're going to go to court and we're just going to split everything 50-50, or this person has to do something because they are the head of the family, but that doesn't fit with the notion of how custody is decided. And so one of the things that, or a lot of the things that we have to think through is working through how do we come up with and how do we address the client's goals that also fit within the law. And I love that idea because we get to show them that the law is actually flexible as long as you are creative and you can come up with ideas and strategize for them, which is one of the things that I think the firm does so very well and is just fantastic at in terms of addressing the diversity of our clientele.
Yeah, just to highlight that point, Bill, because I think it's a really poignant point in the sense that as a firm, and one of the reasons why I was attracted to the firm is diversity as a core value, right? And so I've been in a lot of firms and a lot of different environments, and one of the strengths with which our firm leads is cultural competency. We are competent in the sense that we are trying to learn, listen, and understand our client's perspective, not only from a legal framework, but also from a culturally diverse framework. And that is one of the most unique attributes that you will find in our firm, and that attracts international clients to us because we strive to listen to that cultural perspective. And in everything that we do, not only from a litigation standpoint, but from a family law standpoint, but understand the dynamics also from an estate planning standpoint and also from a probate and a probate litigation standpoint. We're always trying to understand the cultural lens from which our clients are looking, whether they are from South America, whether they're from Russia, Europe, the Philippines. And that is unique in the sense that a lot of firms do not do that. And that sets us apart. And I think our clients feel that in the connections when we have our strategy sessions, when we seek to understand the dimensions of the family. And we're also from the perspective, from an estate planning perspective, but from a multi-generational perspective, right? So you all spoke about, an in vitro fertilization contracts all the way through adoption, divorce. But then, how does that multi-generational family fit in? A lot of my clients are doctors, lawyers, business owners, and they are taking care, and they're part of the sandwich generation. So they're taking care of their elderly parents, and what may be different in the Asian culture, the Filipino culture, or the Latino culture versus an Anglo-Saxon and our American culture. And so understanding those dynamics and then telling our clients and showing our clients in what we do that we understand that perspective. I think that's unique, but I think that's one of our strong points. And we do want to listen and learn. And we do have we do have staff from all over the world.
Absolutely. So speaking to that point, is there anywhere in there, to get down into it a little bit more, from your perspective on estate planning, where have you seen that you've had to adjust documents or plans to kind of fit that, and how has that played out with your clients?
So I was born, raised Catholic, Filipino, and so a lot of my clients are Catholic clients. And the Advanced Standard Health Care Directive here in Georgia does not comply with the Catholic beliefs. It does to an extent, but we've customized our advanced health care directives to take into account whether or not a priest has given last rites, whether or not he's conveyed, the client passing away has conveyed their wishes. And so it's just making sure that that we take all of these nuances because they're so critical. I mean, we listen to the values, the religious beliefs of all of our clients, and we try to incorporate it in everything we do. So even in the divorce context, I'm sure that you've come up with, different strategies because maybe it was, against their religious beliefs or their cultural beliefs, and you had to modify that.
Right. Yeah, absolutely. So when you are going through a divorce and children are involved to that point, there are 4 final decision-making categories that you get, and it's education, extracurricular, medical, and religion. And so in a lot of cases, people are just like, well, mom's going to have all 4, dad's going to have all 4. They're going to split 2 and 2, or one person's going to have 3, or one person's going to have 1. There are some cases where we have gotten very specific on those different decision-making categories like religion. And so you go in and you craft very specific language that addresses both parents' concerns in terms of how are we going to raise this child or these children, and under what religious beliefs, and what does that look like? What church are they going to go to? And so, again, going back to that, not having this rigid idea of, well, you get your 4 categories, the judge is going to decide, and that's it, right? But being able to think through and look and see what values or what is most important to that client, and to be able to weave that into the documents and the law to be able to make it fit such that it is good for their family. Because even though these parents are getting a divorce, they're still a family, right? They're going to have grandkids, graduations, weddings. They're going to see each other forever. And so being able to help them come up with a way that helps them be better parents and better people for themselves and their children is part of it, right?
And
so
that mirrors what's going on, what's going on in estate and probate mirrors what's going on the family law side, because we definitely need to have to put a lot of thoughts. How is the parenting plan, for example, looks like for this specific family? Because a lot of our clients, let's say holidays in religious holidays do not look like a cookie cutter standard parenting plan or holiday split that, let's say, Fulton County has as a standard, or Gwinnett County has a standard. So that's definitely a lot of work that, a lot of thoughts that we are putting into planning, but that is important for our clients. In the skill of listening and trying to understand where the clients are coming, from, what's important for them, what's their values, what's the most important thing for them in the whatever issue they came to us, is a good skill to apply, not just to the cases where people are having completely different background, or where they're from different countries. Nowadays, certain things, let's say abortions or anything related to IVF process, are so, to some extent, political, and the wind is always changing. So it is affecting all family law practitioners, including people who are dealing with estate and probate, including on the litigation side. For example, recent rulings of the court in Alabama put certain strains on the family law cases related to IVF process, and that's the reality. So we are still on the U.S. soil. We are not in a foreign country, but that is something that needs to be taken into consideration, because we have to, for the sake of our client, try to think one step further. So if legislation will change, what's going to happen? What else needed to be put in the contract to make sure these families would not have a huge problem on their hands in the future, if something happens. And of course, we cannot predict the future, but we are trying our best.
Absolutely. So tell me, on the probate litigation side,
Yes.
You don't have an estate plan in place. You're facing a family, a diverse family, or a family that's culturally diverse, and they are looking at a probate court and going, I don't understand why this judge is telling me how, who's going to get, dad's, accounts, or who's going to get mom's jewelry. What is your approach when you're working with clients and trying to navigate that stressor?
I think that we've all said the same thing in different ways, but the most important thing, first of all, is to listen. The client needs to understand, first of all, that you're listening to them, and that you are sympathetic to what their position is. Once we clarify that, then there has to be some time where we kind of take the reins and explain to them from a jurisdictional standpoint what we can and cannot do within the state of Georgia. And if there are any federal implications, or if there are any international implications, we look at that as well. But sometimes there is a difficult time that has to be overcome between the differing views. And what we do is we take our time to process the information for the client through education and through also making sure that we tell them that we understand what it is that they're bringing back to us that are of their concerns. So some of the examples that I can give you that I've dealt with in the past have been where a person has, there have been multiple, I've had an instance where there was multiple cultures within one family and they were breaking up. And so we had to take into consideration, and there is always the opportunity to mediate. There's always the opportunity to settle, and we try our best to do that. So during the course of the settlement process, we look at what the common areas are between them all, and you start with that as a foundation. The foundation is, where can we agree with, and there may be diversity here, but where can we all agree? And then you work from there. You try to find some common ground, and then we just discuss then we delineate the differences and find out the details of those differences to identify, okay, within those differences, what can we give and take in order to reach a resolution, keeping in consideration what the law says about the circumstances. And sometimes it works, sometimes it doesn't. But I think at the end of it, and most of the time when you're resolving, because you've got different views, there's going to have to be some give and take there. But it does, the fact that we take the time to educate the client, which is the most important thing, and take our time in doing that. And what does that mean? Well, that means that we may have to have 2 or 3 conversations with the client to understand what their story is. If the client understands that you are listening and can talk to them and have valuable exchange with them about their story, and then you are able to take their story and present their story on their behalf in a way that is convincing and can move their case forward, then we can start resolving the case and reach a resolution. So when we've got diverse backgrounds, the first thing is for us to do is to take a step back and one of the things that I think we do very, very well at the Manili firm, very well, is that we take what we call deep dives. We are very strategic in talking about the cases and the law and the different approaches that can be taken for the cases. And we go back to clients and provide them with options with respect to that. And then we look towards a resolution with all of those things in mind. We consider our client's position, we consider the opposite side's position, and we discuss what are the strengths and weaknesses of those sides. And we do that from a diversity standpoint as well. And we come up with a strategy that is a living strategy. The strategy can change sometimes based upon what emotions that have been brought to the table by the clients. The strategies can be changed sometimes because of the education that we've provided. So to reach a resolution, there are a number of things that we do at the Manili firm to make sure that the clients are as satisfied as possible under the circumstances that we're dealing with.
Right. And I loved how you talked about you have to show the clients that you care, right? Because they don't care what you know until they know that you care, right? And so to be able to get to them or get across to them, to get them to open up and really feel or see what you're trying to provide them, you want to be able to show them that you care. And so, absolutely. And so going back to this notion of cradle to grave, or this idea that we want a lifetime client, thinking through that, I love, and it's so exciting as we continue to expand and grow as a firm and add practice areas that fall under this umbrella of family law. It's exciting that we are no longer referring out, but we're referring within. So we have this culture within the firm where we say this is the expectation of care and service that we provide to clients. And so when we are able to refer within, we know that they're going to get that same level of service. And that's not to say there are plenty of referrals vendors that we have that are trusted vendors of the firm that we love to work with all the time. But we do have that certain, understanding that if they're being referred within to one of our trusted colleagues within the firm, they're going to get that same level of service. And so when you're thinking through this cradle to grave idea, you have a client that walks through the door, they've got 20 questions. you're able to answer all 20 questions instead of 15 of them, and then going, okay, I'm going to have to refer you out to answer for somebody else to answer these 5 other questions. And they could be anything from, I'm interested in adopting a child, to I'm having some trouble with my spouse. What does that look like? To I want to create this notion, or not notion, but I want to create generational wealth for my family. And I think when we're looking at things, a lot of what we're dealing with, or what we're looking at, are these notions of people care about their time, their money, and their reputation, right? And which, in some order, some fashion of that, and part of all of that, and what they're looking at, is creating this generational wealth. Because I think this idea of generational wealth and setting up your family encompasses all 3 of those. It allows for you to have more time with your family in the future. Obviously, generational wealth, it includes, growing and accumulating money, but also protecting that money and not, frivolously spending it or losing it. And then having additional monies then allows you to have additional time. And so what I'd like to talk about a little bit more, Cherish, is in terms of creating generational wealth, is what are some of the documents that you talk to clients about that they should put in place to protect themselves and their family and their family's future?
Well, definitely. So a lot of our clients are the executives, the C-suite, the business owners, and they are, sometimes they'll be a first generation. And so, the restaurant owners who are trying to pass on that legacy to the next generation. And so one way to preserve the wealth and also the values, right? Their values of hard work, of making sure that the next generation is taken care of and their elders are taken care of. So typically that's done through a trust, and trust can take all types of forms. But, a revocable living trust, I like to draw an analogy to a bucket, and you're putting assets in that bucket. As Stephanie can attest to, when somebody dies without a plan and without a will or a trust in place, honestly, it's super expensive. And there is guardianship and conservatorship, which costs thousands of dollars. The filing fees alone are $600 in court. But you can put a plan in place, and you can direct how those assets are going to be passed down. Also from a tax standpoint, at the end of 2025, there is going to be a change in the tax laws. And so a lot of our clients will fall back, and it will roll back from, a $24 million exemption for a married couple to $12 million. And a lot of our clients fall within that range where you're looking at all of the assets. And so this is something that you need to do, and you can't do overnight. One thing I do want to acknowledge to the listeners is we acknowledge that death, disability planning, all of that can be scary. And also from a cultural lens, that sometimes, I have had some clients say to me that if I speak of death, it's going to come to me. And so we don't minimize what they're saying. We accept it. We walk them through the process, but we show them carefully how what you're doing is protecting and loving your family. And sometimes you're right, Stephanie, that those conversations have to be repeated, and sometimes there needs to be a visual depiction of how that happens, and then a conversation again. But we try to create a safe space to have those hard conversations. And one thing I think that we're really good at is our emotional intelligence. We actually get training on that. And I don't know, if you ask other attorneys, I don't think they do. And that makes us very unique, that we as attorneys, as paralegals, as all personnel in the Maneely firm, we want to grow. Growing is our core concept, but we also want to grow to learn more about our international laws, about our just being emotionally intelligent with our clients. And that is a unique attribute that we bring. It's
definitely a big challenge as far as how do you talk to your clients from different cultures about, on the topic of making arrangements after death. Because, I would imagine in some cultures are more pragmatic about that than others, and in some cultures it's just simply unacceptable to even raise questions in advance, and it's a sign of disrespect. And this is the reality of life, and not everybody. I guess in America it's a little bit more, acceptable and very pragmatic, partially because of the costs that estate and probate consequences will bring, and the debts that family can fall into after their loved ones is passed. But we can also mirror the same on the family law side. For example, in different cultures, the process of legitimation is completely different. Some countries, and legitimation is a process when a biological father officially is recognizing the biological child, if the child was born out of the marriage.
Right, they're getting legal rights.
Yes, to get the legal rights. And sometimes our clients are in complete shock because being a biological father of the child and living with the child is not enough if the child was not born in marriage, or if the father subsequently didn't marry, the father or mother didn't subsequently marry the spouse. Sometimes father and mother and child, or two mothers or two fathers, can live with the child, and then one of them dies, and then the legal consequences are completely different from what the people expect, especially if there was no marriage in place. And it's very hard to explain to somebody why, after fathering this child and living with the child, giving the child his or her whole life, after 10 years, if something happens to the partner, the other partner have no rights to the child. So this is, there are so many tragedies that could be easily avoided with some smart planning, and that's what Cherish and Stephanie do in our firm.
I want to, if it's okay, I'd like to address a little bit of something that we talked about earlier. All right, so the concept of the team that we talked about. So there, we mentioned that you've got the team internally within the firm, and we do work as a team. There, each case is assigned a team. You are provided with extra care through the teams that you're assigned. And I wanted, from a probate standpoint, to touch on the options that you have as clients. So we've talked a lot about planning today. We've talked a lot about doing things from a family law perspective, but from a probate perspective, even when the people that come to us from a probate side are at a very special point in their lives that really, just like family law, require a special level of understanding. And the areas that we cover from a probate standpoint are multiple. We cover guardianships when someone has reached a position within their lives that they can no longer care for themselves and they need some assistance on that. We cover conservatorships when they're not able to care or manage their affairs. And from a litigation standpoint, there may be people that are contesting those guardianships and conservatorships. And we are here to help with that side of the coin as well. From a decedent's estate standpoint, if someone has passed away with a will, or if they've passed away and they don't have a will, and there may or may not be some objection to that scenario, we can provide you with the guidance that you need through that process. These are very, very sensitive areas of people's lives, and we do lead with care as we advise you through those processes. There are also the issues that involve trusts that Sherry's talked about that get a little bit out of hand. And in those instances, we're there to provide you with the litigation services that you need if, for example, the person that has the responsibility of marshaling assets and making sure that they're handling and managing those assets to the benefit of the trust assets themselves as well as any beneficiaries. They sometimes don't make the right decisions. I have litigated cases where brothers and sisters have taken advantage of moms' affairs and have exploited them and have put them under duress to get them to do what they wanted to do, or caregivers that have done the same thing. We are here to help you through those very, very tough times. We also are, if there are any other business implications that you may need. I think it's important that you recognize that our firm is so skilled that we're able to provide you services in other areas that are related to these that we've talked about today. As an example of that, when you have family law cases, when you have estate planning matters, when you have probate litigation cases, they involve other areas of the law, such as real estate litigation, business operations, real estate conveyances, real estate transactions. Guess what? The Manili firm can handle those matters as long as they're family law related. And I'll say that we can do that from a probate standpoint. It's limited. It is limited from a probate standpoint and from a probate litigation standpoint. And to the extent that we don't handle those matters, we will refer you out to capable hands. But we are the firm to go to for those types of matters as well. It's comprehensive service.
Yeah, absolutely. And you talked a second ago about guardianships and conservatorships, and I've actually had divorces that cross over and have had guardianship and conservatorship issues where we're making determinations on whether one litigant or the other has the capacity or the competency to be able to litigate that and make decisions for themselves in the divorce action. And so crossing over and being able to answer all of those questions and having, a team within the firm to be able to handle that. It goes back to this notion of cradle to grave or a lifetime of care and being able to provide answers in many different areas of family law, across that spectrum of work and underneath that umbrella of what we call family law. And so I just want to say thank you to everybody for joining us today. We look forward to seeing you again soon on our next podcast for Family Law Matters for our 3rd episode. And if you want to learn more, go check us out at www.allfamilylaw.com. Thanks again.